When thinking of industries with lots of data to sift through, it doesn't take long to think of financial services. Here, our next speakers will discuss data mining and how it can be used to make strategic decisions, eDiscovery, and how to prepare for litigation, and what best practices to use when managing sensitive data. Please put your hands together for our speakers, Mr. Paul Friedman, Litigation Chairman for Accident Law Group at Brown, Crowell, and Friedman, PLLC, doing business as Accident Law Group. Ms. Katharine Perekslis, Vice President of eDiscovery Services at TransPerfect Legal Solutions, and Ms. Brittany Field, Director of Consulting at TransPerfect Legal Solutions. They will talk on the topic of data mining and eDiscovery. Can investigative services professionals benefit from LegalTech? Thank you.
Good afternoon. You know, it's really nice when there is a 3-day conference and you know that you have been selected to be the last speakers at a 3-day conference in the last hour when everybody's trying to get out of sunny Las Vegas to hit the winter storms going back to their homes to make it home before Christmas. So we're really pleased that these 200,000 people have remained here to listen to this topic. My name is Paul Friedman, and I am a litigation attorney with Accident Law Group. We are a national law firm. We have offices primarily on the west side of the country, but we are branching out, and we handle mostly mass tort situations. We also handle very large cases, medical malpractice cases, racketeering, civil cases, and financial fraud cases, as well as vulnerable adult cases throughout the U.S. So that's to start off. Brittany, do you want to introduce yourself?
Sure. I'm Brittany Field. I'm a Director of Consulting Services at TransPerfect Legal Solutions. I work with Katie as well. I primarily focus on data analytics and helping clients who our clients are usually law firms to help cull their data, make sense of their data, find what they need, and also just help produce in a timely manner.
And I'm Katharine Perekslis. I'm the Vice President of eDiscovery Services at TransPerfect Legal Solutions, along with Brittany. And I oversee a team of 150 project managers in 20 offices across the globe. So we deal with cases, everything from, a very small, messy divorce investigation all the way to, really complicated, large antitrust litigation or a merger review where we're dealing with just terabytes upon terabytes of data, all the way to investigations of potentially, employee fraud, employee departure investigations where we're trying to figure out if an employee has taken any protected IP with them when leaving a company. So we just work with kind of a large variety of data, and we just help our clients try to navigate those difficult situations with large quantities of data and trying to find very specific information within that data. So today we're going to talk a little bit about eDiscovery tools in the context of investigating and interrogating your data, not necessarily in the sense of preparing for production for a large litigation, but when we're really just trying to find that needle in the haystack.
So I feel really honored because I'm not really an expert. I don't profess to be an expert in eDiscovery, but I can give the legal aspect, but certainly Brittany and Katie are the experts with regard to this field. I just wanted to start out by talking about maybe one of the largest cases that I was involved with, which was in 1996 to 2000, which was a small case in the United States called the people of each individual state versus Brandon Williamson, which was the tobacco case. And I can tell you that I served as a special assistant to the Attorney General in the state of Arizona, specifically for Arizona with regard to that. 49 states were represented. And I can tell you that out of discovery, which I was primarily responsible for during those 4 years, we literally had millions upon millions of pages of documents. And we, in fact, had to hire warehouses to store the documents that we had at that time. So I can only tell you that from my perspective as an outsider in this field, that this is really a growing and evolving field and a much more cooperative field, because if I needed to go and find a particular document, it would take literally days to weeks to months to find a particular document that I would need. Now with what you guys do, we can really go through and do a search and find it in a matter of seconds. So let's talk about just the general area of eDiscovery, because it is relatively new. eDiscovery is now recognized in all of the 50 states in the United States. It's also recognized in the federal court system. The federal court system actually was ahead of its time with regard to eDiscovery. There are specific rules of civil procedure with regard to eDiscovery and how eDiscovery needs to be requested and how it needs to be produced. And I can only tell you as somebody that is the end user of the material what it is that I would request, but it is really Brittany and Katie's job to go and actually find the material and to be able to put it in a way that I can deal with it as a lawyer if the end result is it needs to go to a lawyer. So let me give you a specific example, and then I'm sure Brittany and Katie have their own examples. I was involved with a rather large medical malpractice case, and it involved a physician who was, in my estimation, providing drugs for sex. He was giving prescription medications to a patient, and in return, he was getting a sexual relationship out of that patient. So let me just tell you first of all, as a bioethicist, probably not a good idea to sleep with your patient if you're a physician. As an attorney, probably not a good idea to sleep with your client when you're an attorney. As any fiduciary, it's probably not a good idea, and it's probably the fastest way that you're going to get taken out. And this doctor, unfortunately, was removed, or maybe fortunately, was removed from the practice of medicine. But in the process, we asked for all of the chat information, all of the instant dialogues that went on between he and his patient, all of the emails and texts that went on between he and his patient. And just in a very cursory glance, we actually utilized a service, and they told us that there was a lot of missing information. And how do they do that? Well, they actually go through and they probably read a lot of the material. And there was a lot of clues in there, including this individual who was talking to his private attorney, even though he was represented in the malpractice case, but he was talking to his private attorney, who said, I don't want to provide my attorneys with all this material because they're going to provide it to the other side, so what should I do? And his personal attorney did what you would expect an unethical personal attorney to do. He told him to destroy it. So what does he do? He destroys the material. I can tell you this is a gold mine, because generally we don't have emails or texts where they talk about destroying information. But if I'm on that side and I'm getting this on my side, I'm excited to show that to a jury. So let's talk about what happens who is it that's going to contact you guys for a service?
So our clients are typically either law firms or corporations, occasionally individuals, but typically law firms and corporations. Sometimes we wind up working with, a situation where it's a corporation and a CEO who wind up being named as co-defendants, and they start with their interests aligned. They wind up getting different outside counsels during the process, and we split up and we put a conflict wall in our internal teams because the interests are no longer aligned, but we can still help, with them sharing costs, but kind of doing separate investigations into the data. So our clients are everything from law firms to corporations to individuals. But most frequently, the parties that we're communicating with are the outside counsel, so the law firms. Probably similar to yourself, the people who are doing the investigation and trying to figure out what are the facts of the matter, is this allegation, does it have any merit? And so what we'll do is we'll start with a really high level analysis. We'll take our tools, we'll run it through our processing tool, we'll run some basic analytics, and we'll say, okay, is there, are there any obvious gaps in email? We'll do a nice histogram on the email and see, okay, are there any really like unexpected dips? We'll run what we call a 0-day report, which will tell us if there's any day where there's zero communications coming from that individual. And, if we see that on the weekends, holidays, okay, maybe that's expected. Maybe they had a week off, sure. But what's going on in this dip in communication on a day when this individual normally sends 300 emails a day and they've sent 10, that's really alarming because they were working that day. What's going on? Were they in a conference? No. Oh, well, we see a spike in text messages on that same day. Well, that's concerning. So maybe they took their potentially nefarious activity off of email and put it onto text message. So we know immediately that we want to hone in on that day's text messages to see what's going on. So we can just kind of see patterns in the data even that give us good information about where we might want to start that investigation. Brittany, do you want to talk a little bit more about that?
And I mean, a lot of times it can be helpful. We don't have all the details up front, right? So they might say, can you do a little bit of analysis? And we'll come back and say, here's what we're seeing. We're seeing on this day, maybe this person is sending all their emails to their personal email address. Why would this be happening? And sometimes it's sort of like this back and forth. This is helpful. Can you look into this? We also, are there emails from this person we've seen, and maybe give various emails, and we can sort of find aliases, different email addresses that different people have worked under. I mean, there's so many tools to, like Katie was mentioning, anomaly detection.
Yeah, and also if you're just saying you know about two individuals that maybe have been corresponding, maybe the guy that you're talking about and his personal attorney, and you want to see, okay, show me those conversations, you click on that and then say, what are the key phrases that have come up the most between those two individuals? What topics are they talking about? And like Brittany said, anomaly detection. Where does the phrases that they're typically using to correspond vary? Where's that? When does that change in tone? And then we can run something like called sentiment analysis, which is really cool, which tells us where there's a lot of negative or hot words that are happening that might indicate nefarious activity.
So let's break this down a little bit, because I would assume that a lot of people watching this are going to be attorneys. What is the actual data that you all collect?
So primarily, the bulk is email, hard drive collection, but more and more, we're seeing cases where there are younger founders of many companies. So email is not how they're communicating. It's now text message, it's now Teams, it's now Slack, and their Telegram. There are any number of sort of challenges with new ways of communicating. One of the challenges with sort of Slack and Teams data and things like that is that a lot of analytics we would use on email, for example, finding more like these documents or prioritizing review using sort of different models, is that in sort of short text messages or Slack or Teams, a lot of times messages are so short, and so you could sort of mix in, did you watch the World Cup game, and then you go right into a topic relating to a completely different matter. So those present a lot of challenges that we have to kind of keep us, I guess, on our toes in terms of keeping up with the latest technologies to help the clients get the most out of this and not waste time on dog and puppy messages.
So let's take emails for instance, because a lot of those things that you're talking about, me as a 50-some-old attorney don't know a lot about. I mean, I know about team meetings, I know about instant communications. I know some of them are destroyed immediately. Are you able to mine that material out?
In terms of like ephemeral messaging. not.
It depends. It really
Yeah.
depends on the settings. It depends on the corporate settings. There's different ways. Most of it's not gone, but some of it is.
So let's just talk about emails. When you get an email, what format are you getting it in?
Email we typically receive in what's called a PST file, which is like a container file full of emails and its attachments. But what we're seeing as a challenge today in eDiscovery is what is being referred to as modern attachments, which is actually really just hyperlinks inside of the email to an internal system. So for example, in people who work in Microsoft 365, oftentimes they have an internal SharePoint where they can share and collaborate on documents. And instead of actually downloading and attaching that Word document and sending it over email, they'll just send a link to that Word document. But what's challenging is that Word document has multiple versions that get stored. It gets saved every 30 seconds or something in Microsoft 365. So it's trying to find that closest point in time match to when that email was sent to show that you're actually seeing the content that the recipient of the email saw. But what if they didn't click on that link for 3 hours, and so by the time they clicked on the link, it was a totally different document. So it's a really interesting challenge that hasn't been sort of for once and for all decided how the industry is going to approach it and what's going to be the acceptable solution. So that's an interesting challenge that we're facing right now. And like Brittany mentioned with the short message formats, another challenge that we're seeing is a lot of people communicate with emojis or GIFs, right? You're not responding with words, you're sending a GIF, and the description of the GIF might not be what you intended as a reaction. But so that's where I think, a lot of the panels at this conference have been talking about, is AI going to replace human interaction with your documents and with, performing these tasks? And in our situation, we're talking about document review. And I think we're not there yet because all of our data types keep evolving and the way that we communicate keeps evolving.
So that brings out an interesting point. Let's say I'm using SharePoint or I'm using 365. And it is instantaneously saving as I'm doing a document. And the discovery request comes in and it says that they want all versions of this document. What do we do?
We need the lawyer to do the lawyering. No, we've had.
So in other words, don't call me at that point.
No, we are doing this presently, and then we're going to have to do some work to link things up. Like Katie mentioned, I think for a time it was, the minority of emails, fall into that bucket where there are these modern links. So but as this changes, and there are even policies within some companies and corporations that prohibit sending attachments, and they must link to their SharePoint or OneDrive. These are sensitive files. These are like important trade secrets and details about their products.
So it's difficult.
It's a challenge, and I think you work with your vendor. You do the best you can to work with the other side or a regulator, and the vendor, or we have to do, we come up with creative solutions to make it happen, basically.
And the answer to your question is, if you want every single version of the attachment, is it possible? It depends a little bit on the organization's settings, on how they've set up the M365 SharePoint environment. And I think that we will, in the upcoming probably months to year, get some guidance from court decisions that come out on what the best practice is, and we can start advising our clients, even on the proactive front, on the corporate client side, to say this is how you should set up your environment so that you can comply with these requests.
So let me talk about that from an expert standpoint just for a second, because I deal with a number of experts throughout the country and actually worldwide. And we routinely have this discussion, depending on the jurisdiction, is what are they supposed to be saving as far as their preparation work? What are they supposed to be saving? Because I generally, when I serve as an expert, I generally don't save anything. I do the work in my head first, and then I type it out into an outline form, and that outline form becomes my federal report. that includes my curriculum vitae, and I don't really have a lot of different drafts of the documentation. But there are times as an attorney when I hire an expert, and it may be important that I inform them what the jurisdiction is, what the rules are of that jurisdiction, and what they actually need to do to make my life easier. Because the worst thing that can happen for me is I don't have that discussion with an expert. The expert starts changing things and doing redrafts and redrafts, is not saving those drafts. And at the end of the day, a court may order that I have to produce those drafts depending on where it's at. And I can't do that because those drafts haven't been saved. Now, it may cost me a lot of money to have to go in and hire you guys to go in and see if, just even out of good faith, that I have to go in and hire somebody to see if we can save those drafts. Whether we can or not is not really as consequential for me. But I need to show the court that I'm doing everything I can to comply with the court.
Right, and that's really going to be an expense that your client's going to have to bear, right? So kind of your job is, like you said, important before you hire the expert to understand what the laws are in the jurisdiction, in the court that you're operating in, and advise the expert prior to even starting work.
What experience have you guys, do you guys have with regard to the mass tort world? Are you now evolving into that type of work?
To what, mass tort work?
Mass tort work.
So that's interesting. That's come up this week a little bit with, do we have a solution where we can kind of manage that process? And we do, but it's not an exactly perfect solution. So we have, platforms where documents can be reviewed. We have platforms where we can store a lot of information about documents that have been reviewed, but it's definitely not an area that's fully within the eDiscovery bread and butter realm.
Yeah, I have nothing to add to that.
Do you guys foresee that your practice is going to evolve into a mass tort repository of documentation so that the attorneys on both sides, let me give you another example. Tobacco was a great example. A funny story with tobacco is we probably did 500 depositions of various state employees through experts in the tobacco case. We probably had over 100,000 exhibits to that. And at that time, we were doing all these and they were being videotaped, but it was by the old VHS videotape. So nowadays we get the MP4s and they're consolidated and they're easy. Back then we were doing it by videotape, and I remember getting a call from a very alarmed court reporter after, I'm just guessing, the 330th deposition of 500 depositions, and she said, I'm missing exhibit number 62,953. What do you do? So now I can say that we're in a much kinder era where I provide all of those things digitized, especially in the larger cases. They're all digitized. I provide them to my videographer and my court reporter in a digitized form to make it easier for them. But I remember another case. It was against a very large healthcare organization. It was actually the number 2 health organization in the world at that time. And it was a case where we had 660 psychiatric abuse cases, mostly targeting children, throughout usually the southern part of the United States, because people with really good government plans in the 1980s and 1990s, the government plans paid a lot of money, and they paid a lot of money for psychiatric help for children especially. And so these parents that were being talked into the fact that their child is catastrophically mentally disturbed and depressed, ready to commit suicide, they would generally place their children in a place that happened to be sunny, like Arizona, California, Florida, Texas, just out of pure coincidence that it happened to be a sunny place. And so there was a number of cases along the southern United States. And I remember that we had a warehouse where this particular company was, and it was in Santa Barbara. And that warehouse cost us so much money just to maintain, to present documents. And then again, we had the same problem where we had no way of actually, I remember we found some hot documents, and it was purely by luck that we knew what we were looking at to find it. Because most of the time, as the attorneys that are watching this will know, it's pure luck. It's hit and miss, and you're finding the right document. Now with what you guys do, you can really turn the luck into a science of finding the right documents in the right places.
Yeah, Brittany, can you talk about like how we would, go about finding hot documents today using analytics, and even what we would do if we didn't already have a good example of a document?
Sure. I would say in that example with the boxes of data we're coming across sort of medical record companies that are approaching us to scan all of those boxes so that they can reference back to those files. That's a job unto itself. But sure, so there are oftentimes, especially in investigations, where it's suspected that something is going on, but you don't know what, or you may have an inkling, but it's not as easy as applying a search term. Usually using a search term for, what you need to find is easy, but if you have a search term for what you don't know, it's either going to be overly broad or overly narrow. So with analytics, I don't want to get too specific or too like in the weeds, but we can build basically a conceptual index. So an analysis will be run on words that are happen frequently together, so that you can type in a phrase that you think, or if you have maybe you could even create a dummy document. We often do. If I had a perfect document, this is what it would look like, and we can use that to sort of lead us to similar documents. We had a case where there were a number of state and DOJ subpoenas, but they also, since they had the data in the workspace, they suspected that there was some promotions happening, that really shouldn't have been happening, or something kind of was going on the side. One too many steak dinners or something like that, and so sometimes it's helpful to hop on a call with the client, kind of share my screen and say, what is it you're looking for? What do you suspect that's happening? And you can kind of, I drive, and they, kind of give me some details about what they suspect might be happening. And it's amazing how quickly you can find something. I'm sort of using this conceptual index to find things that you didn't even think you would find.
Yeah, we had a case recently where there were allegations that the CEO was having, the married CEO whose wife also worked at the company, was having an affair with a junior level employee, and it turned out that we started conducting the investigation. It was never completely conclusive what we found, but we did find a lot of bonuses that were getting paid out to this junior level employee. Trips that were being expensed at 5-star hotels. She was approved to execute deals that were outside of the allowed scope of what they were allowed to do as an exception frequently, because they were a really high commission. And there was a lot of evidence that we did find that supported that allegation. But what happened that was interesting is, because we started saying, well, let's see if there's any other situations where really extensive bonuses are getting paid, or trips are getting booked, or are there other deals like this that are getting exceptionally approved? And we started seeing that, and then we started saying, well, what's the communication happening between these two people? And we did prove other affairs from other executives in the company with lower level employees. So it was like the company had hired us to conduct this internal investigation to see if they had problems going on. And we did actually, using those tools that Brittany was talking about, find things that we didn't even know we were looking for.
So it brings up an interesting case that I remember having, which involved a negotiation of a professor at a university who was brought onto the carpet for things which I would say were educationally responsible comments that this professor had made in front of a class, and one of the students took exception to it. But I thought it was an absolute appropriate a dialogue that goes on between a professor and the class. And the school was going to take some definitive action. And, you know, it was an interesting case because the discussion that I had with the professor was, you know, whether this was probably within the normal course of dialogue of a professor with students. But more importantly, I needed to know as the lawyer that was negotiating, because it was pretty obvious that the university wanted to do away with this professor. Becomes very obvious when they, you know, start making allegations that are probably not supported. And I said to this professor, tell me what it is that I need to know that's not part of this investigation. Mm-hmm. Because I need to know what's out there. Because if it's not part of the investigation now, once they tie into your emails and to your chats, mm-hmm. it is going to become part of the
You may go down for something else.
and we had a very lengthy discussion, and I can tell you from a legal standpoint, it's so important to have that trust of your client and to be able to talk to them. And the same is true, you know, with your guys' service and the attorney. It's important to have a trust and a dialogue that goes through, because it turns out that there was probably going to be some material that was brought up that was going to be very unpleasant. And it made it a lot easier for me, mm-hmm. while I still had leverage, because the reason they were going to terminate the professor, I felt was not justified. It wasn't for cause, but it gave me a lot of leverage before they actually did an investigation. And, you know, they didn't know what they had out there, but right. I was pretty sure that I knew what they had out there. So it just gives, you know, examples of what needs to occur. But I think that your guys' service is really important for the legal industry, and I think that they need to engage in utilizing your guys' services more, and I think that they are.
I think that that's true. I think lawyers are getting smarter about technology and trying to understand what's available to them. And I think one of the things that we really, really encourage is for lawyers to spend a couple of hours conducting early case assessment. The data is there, the analytics tools are available. If you use them, you can advise your clients better up front. You can find out pretty quickly if there's any there, right? And mm-hmm. let them know, okay, there's some there. We might want to settle this one. Let's not spend all your money on my time. Let's settle this now so that we can get in front of this before the other side figures out what's actually, you know, going on here. So it's really important to have that information.
Yeah, I mean, there are some matters where ideally you would like to get eyes on documents that you produce, but there are matters, you know, especially HSR second request, where you will not get eyes on every document that you produce. And we have things like running profanity models, you know, just to flag anything, because similarly they don't want to hand anything over that could be, you know, have nothing to do with a merger or an acquisition, but is damning otherwise. So catching that is important.
And something that was brought up on the data privacy panel that I sat in on yesterday is that a lot of these filings are for court are public filings. So it's really important for your clients to know what's in there and for you to be able to tell them, hey, look, I found these documents. It has nothing to do with the case. It's not going to impact the merits of the case, but it might be really embarrassing for you, for the world to know that, you know, you're having an affair with somebody outside of the company. Maybe it's not illegal. It's not a problem for the company or for the case, but it might be pretty embarrassing for, you know, your spouse to find out.
No, and I think that that's also a good point. I think that that's why there needs to be a collaboration and a cooperation between your guys' service, the lawyers, and probably the clients, and that when that information, and that those things do happen frequently. I can't tell you how many times I talk to a client and say, you know, I've discovered some embarrassing things. It has no relevance in court, although I'm not the judge in it, but I can, after doing this for 30 plus years, tell what I think is going to come in or not. But there are things that I can do as an attorney as well. And some of those things that I do, I may contact the other side if I trust the other attorney and say, here's the material I have, but I'm not going to release it to you because it's, in my view, it's not relevant. I will release it with a protective order. And it's a way that I can keep that material confidential so that it's not being exposed in a court process, because court processes are public hearings. Everything that goes into that I file with the court is a public record. The other way that I can do it is if I can't get cooperation from the other side, which unfortunately does happen with attorneys.
What?
Believe it or not, some attorneys are obstinate. They don't want to give their permission to do certain things. I may have to go to the court and file something under seal and let the judge decide for me whether, that is something. And I've found that judges are really good about not wanting to embarrass the parties or the witnesses in a case. And there are ethical rules with regard to filing things that are just made to embarrass parties or litigants or witnesses, and those things are probably ethically inappropriate in most states. So there are things that we can do working together, I think, as long as there's cooperation between everybody involved.
Have you ever been able to get approval, or have you considered applying like redaction for not responsive content?
That's a really good question. So there are certain things as lawyers that we do. There are documents which I will redact. And then I have to include a privilege log explaining exactly what I'm redacting. It's extremely time consuming.
Yeah.
And if a client is paying me by the hour at $600 an hour, it's pretty cumbersome. That is something that I may actually ask you guys to do.
Right.
Because it may be more cost, it's probably more cost prohibitive for me to do it. Even though I need to know what it is and we have to work together, because I'm still going to have to provide a privilege log at the end of the day. And I have fought privilege logs a number of times. And what it comes down to is filing a motion to compel on one side or a motion for protective order on the other side, and then allowing the judge to do what we call an in-camera inspection, which is, just looking at the documents with the judge, and the judge will decide whether the material is relevant, whether it should be disclosed or not. But it's happening more and more frequently, and I think with eDiscovery, that's something we're talking about. Some cases we're talking about in mass trust, in mass tort cases, we're talking about millions to tens of millions of documents and material within those, or some of it may be relevant, some of it may not be relevant. So it really does come down to really knowing what you're doing and trusting your vendor, from the legal aspect. So any closing words?
I think from my perspective, I think what you touched on with trust and communication is so important through all the parties involved. And then just, understanding what technology is available and implementing it in order to support and make the process more efficient and give you more insight into your data.
Yeah, I would just say the needs are always evolving, the technology is always evolving, the tools we're using to communicate are always evolving, so we just always do our best to keep pace with that.
And we'd like to thank everybody for participating in today's discussion. Special thanks to Katie and Brittany, and we hope that you enjoyed today's conference.
Thank you, everyone.
Thanks.